Madam, you are paying for Panchayat Development Officer. Why you are silently just watching? You have to answer. Panchayat Development Officer, you are appearing. You should answer. The order against you. Yes, restraining you from carrying out any further work relating road till get appearing. There is no complaint.
My lords, may I make a submission, my lords?
Yes.
My lords, in this case, my lords, the road was in existence much before the writ petition, my lords. Earlier, Panchayat had formed it, my lords.
We should have gone before learned single judge.
We have filed vacating application, my lords. We have filed application before the learned single judge, my lords.
Where you have stated in your affidavit.
Not yet filed my objections, my lords. Not yet filed my objections, my lords. Pray for a week's time, my lords.
What, sir? 2019.
Sorry, my lords. Recently, I entered appearance, my lords. One last final opportunity, my lords.
Where is this Ashwaya? Compliance office objections. Pastor, let it come.
Please.
Yes, Satraj. You know? Pastor. Pastor. Yes, Sunil. What affidavit, sir? No complaint. Seeking drop. Why? Unless you complied. What is the violation, sir? Twenty-one. 21. Application. Application so on the part of allowed compromise report so on so. Certified compromise certified. Parties adapted to pursue first matter and the contempt. Very contempt. Guru. Principal factor that the order to 21. What is the certified? Certified. Why the compromise? Was that market? Why the contempt? Where's who appears for the complaint? Silent. Why the contempt? Yeah. Where is the complaint? Pass off. What, sir? Okay. Yes. No, when Matt came out for this court on 22/11/2022. Finally, 1 week time was granted a request to the accused. Comply, failing will accused shall present for the court. What is the violation, sir? Lecture B. It allows the input set aside. Respondents are directed to accept the petitioner's application for voluntary return and grant pension benefits all the permitted retire. The benefits are given or not? Mr. Answer court query. Where is that? We are not here to calculate here. It's not executing court. Please read page 26. You people converted the contempt court in the execution court. We have stated in the upper weight. Totally 8 number out of. Oh, no.
Upendra Naika. Upendra Naika. 8 number.
No, show from your upper weight. You have stated after the retirement granted, enter the punishment, the retirement benefit grant. Right there. Yes.
This is about 8,50,000.
What is this order dated 13/9/2006? The learn single they report to in the order. No. All other emoluments in terms of the aforesaid judgment. Learned single judge dated 13/10/2006, made in WP 19/4/31/2005. Where is that?
Based on that, they will not. Discussion will not end. Okay, as the candidate period or not. Learning has been considered. Based on that, plus he had no qualified service. 1 years. We count not the years service. For that, get 15 years, then not.
Response on to we are directed to pay pension of the petitioners on the basis of the qualifying service counted from the date of the initial appointment and on the basis of the actual emoluments drawn, including the increment, promotions for long-run period, permit to them commute 1/3 of the pension with the consequent benefit interest, so and so, so and so. ಎಲ್ಲಿ ಮೊದಲು ಹೇಳಿದಿರಿ?
The memo method of January 1st November 2019. Statement of
As per page 63, the order passed in the earlier writ petition, you were directed to pay the pension on the basis of the qualifying service counted from the date of initial appointment. What was his initial appointment and what was the amount due and how much is the interest he is entitled? On 7? Yes.
He wanted the resignation.
So from 1/7/1987, he has to be given pension, 1/3 of the pension. Then interest, where is the interest portion? Yes.
25/11/2019.
12/11.
4,30,149.
So apart from 8 lakh and all, you have to pay 4,13,700.
Although where I stated, in terms of the order of this court, pay it from the date of initial appointment till the retirement with interest, where I stated in the affidavit. You should have said in the affidavit, the date in the date on the new blur, go to Melam, what is it? Clarity, Lada Tata. Yes, sir. Let him argue. Why you are disturbing him? He's arguing. Yes, come on. What the discrepancy, sir? Where are they? It's show from their affidavit. Hmm. No, Mr. Sunday, come to your page 16, upper bit. You counted from 4/3/2008, not from 1/7/2087. Sir, we will not decide issue. Rightly, wrongly, single judge says they are entitled interest, pension benefits from the date of initial appointment. Show from your document. Now you have produced annexure page 16 along with the counter. You started period of pension arrears from 4/2008. Initial appointment 87. How can you do it 2008?
2008. The 2008 ಅಲ್ಲಿ the date now, yes, the private body, yes, come to the industry,
That is not the order passed by learner single judge. Right. That is the submission, we will claim the charge. You should have said in their affidavit, that is not the order passed by learner single judge. Read. The learner single judge order, page 63. Please 63 page was this, sir. You can't go beyond the order. The page 26, the learner judge says, while setting aside the endorsement issued by you, allowed, directed the respondent petitioner's application of voluntary retirement can be granted, and all emoluments in terms of the judgment of so and so, dated so and so, where this judgment says you pay the benefits from the date of initial appointment. If you are agreed, you should have challenged.
Appointment is for the private body. This body is not really.
That we can't interpret, sir, please. Come to page 53. 63 bane. Let you frame the charge. Then we need to declare evidence to frame the charge. Where is the accused? That is not the order. You should have challenged the order. Namak sambandha illa government. If government not paid, will initiate action against government also. Government is not big. They are also accused before the court.
When state government cannot, the first respondent cannot, please see the aspect of the sentence.
Yes.
Up to 2008, we are granted.
Yes, Mr. Government. ನಿಮ್ಮ ಅಪ್ರಿವಿಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅದಲ್ಲ ನೀವು ಹೊಸದಾಗಿ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. You should have said in your affidavit. ಕ್ಲಾರಿಟಿ ಇರಬೇಕು ರಾಜೇಂದ್ರ. No clarity. ಇಲ್ಲಿ ಬಂದು ಹೊಸದಾಗಿ ಎಲ್ಲ ಮಾಡಿ will not go beyond the scope of the contempt. Yes, government. Order is respondents are directed to accept the petitioner's application for voluntary retirement, a grant pension benefit, all other emoluments in terms of the judgment so and so. The judgment says they are entitled pension of the petitioners on the basis of qualifying service counted from the date of initial appointment. Yes, sir.
They have to discuss that.
Oh, ನಿಮ್ಮ ಮೇಲೆ ಅವರು ಅವ್ರ ಮೇಲೆ ನೀವು frame the charge, then ಬಂದು evidence ಹಾಕೊಡಿ. We'll frame the charge. Where is the accused? Mama. Though the order passed learner single judge. ಮಾಡಿ ಚೇಂಜ್ ಮಾಡಿ ಕೊಡಿ ಯಾವ್ದಾವ್ ಕೊಡಿ ಚೇಂಜ್ ಮಾಡ್ತಾರ ಅವರು. Order pass against the designation, not against any person. page 19. The order for learned single judge, Government of Karnataka Commissioner, Registrar of University, Yardav Bhattare. They have to comply. Wasting public time, sir. Now, according to you, they have to pay. According to them, you have to pay. It's a matter of evidence. You see, ಯಾರು ಕೊಡ್ಬೇಕು ನೀವು ಹೇಳಿ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ನೋಡೋಣ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡ್ತೀವಿ ಆಮೇಲೆ ನೋಡೋಣ all right. It is unfortunate that though the order for the single judge exam back as 26 July 2018 made in WP 10/7/36/2010, wherein the learned single judge allowed the writ petition and set aside the communication. Who issued communication? Mr. Annexary, issued by whom? And set aside the communication dated 8/9/2019 and directed the respondent to accept petitioner's application for voluntary retirement and grant of pension benefits and all other emoluments in terms of the judgment dated 13/6/2006 made in WP 19/4/31/2005. The learned single of this court in the said writ petition all right. The learned single is referred to above directed the respondents to pay pension to the petitioners on the basis of qualifying service counted from the date of their initial appointment on the basis of actual emoluments drawn, including the increments, promotions for a non-grant period, and permit them to commute 1/3 of the pension with consequential benefits with interest thereon at 6% per annum from the date of the amounts were due till payment. Admittedly, the order passed by the learned single judge dated 26 July 2018 and the order passed by the learned single judge, which reliance is made, dated 13 October 2006, has reached finality. First up, the university filed counter to the present contempt petition. ಬಂದಪ್ಪ ಎಲ್ಲ ಹೇಳ್ತೀನಿ ನೋಟ್ ಮಾಡಿ. ಪೇಪರ್ ಆಗತ್ತಲ್ಲ ನೀವು ಹುಡುಕಬೇಕು. The principal university, College of Arts and Commerce, SMR Pastoral College, filed the reply affidavit appeal number 4 and specifically stated para 7, 8 as under. ಇನ್ನೊಂದೇನಾದ್ರೆ ಎಲ್ಲಿದೆ ಎಲ್ಲಿದೆ ಅದು and the professor Bojanai has filed the affidavit on 31/10/2019 at para 4. All right, para 4. Paragraph 4, paragraph 4, 5, 6, 7 as under. The government, where are objections? Without objections. Where is memo calculations? Where is government? Whether you have filed objections or not, government has not filed any counter. What is it now? On what basis you have done this? The memo for complaints filed by the government advocate today, 29/11/2022, along with the statement account of the complainant stating that amount has been paid, a sum of rupees 8,07,457.36. The learned counsel for the complaint submits that the order passed by learned single judge dated 26th July 2018 and the reliance made on the order of the learned single judge dated 13th October 2006, directing the respondent accused persons to pay pension to all the complainants on the basis of qualifying service counted from the date of the initial appointment, on the basis of the actual emoluments drawn, including increments and promotions for non-grant period, and permit them to commute 1/3 of the pension with consequent benefits with interest thereon 6% per annum from the date of the amounts were due till payment not complied. First up, the university council for university submits that according to the university calculation, they have paid the entire amount. According to the learned government advocate, though objection not filed, counter not filed by the memo of complaint dated 29/11/2022, he submits the amount has been paid. There is no clarity in the affidavits filed by both the university as well as the government whether strictly they have complied the order passed letter single dated 26 July 2018. In the absence of above, this court cannot sit and calculate the contempt proceedings. Thereby, it's a fit case to frame the charge. The accused persons are thereby directed to present before the court to either frame the charge. Yes, that could be. Let all the accused persons before the court. The learned government advocate shall ensure the accused number 1 to 3 shall present before this court on 6th November, 6th December, and Sri Rajendra should ensure the presence of accused number 4, accused number 4 and 5 before this court. Will frame the hear and frame the charge. Here in Mesro. You should read the papers thoroughly. Make the note. What are the some calculation, you are not read the papers. Half-hearted argument madangilla. Full outcome barbeku. Manuspurti argument barbeku. Half-hearted argument madangilla. Next time hang marda bradilla. Yes. Odbaku. Kanna odbaku points ಮಾಡ್ಕೊಂಡ್ ಬರಬೇಕು. ಅವ್ರ ಅಪ್ಲೋಡ್ ಇಲ್ಲ ಮಿಸ್ಟೇಕ್ ಇದೆ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಬೇಕು. ಜನರಲ್ ಆಗಿ ಹೊಡೆಯೋದು ನಾವು ಹುಡುಕಬೇಕು ಎಲ್ಲಿದೆ ಅಂತ. ಅವ್ರು ಹೇಳಿದ್ದನ್ನ ನೋಡ್ಬೇಕು. ಇದು ದಿಸ್ ಇಸ್ ದಿ ಆರ್ಡರ್, ದಿಸ್ ಇಸ್ ದಿ ಅಫಿಡವಿಟ್, ದಿಸ್ ಇಸ್ ನಾಟ್ ಕಂಪ್ಲೈಂಟ್. ಹೊಡೆದ್ರೆ ಹೇಳ್ಬಾರ್ದು ಮೇಲೆ ಎದುರುಗಡೆ ಅವರು. ನಿಮ್ ಎದುರುಗಡೆ ನಿಂತ್ಕೊಂಡ್ರೆ ಎದುರಬೇಕು ನಿಮ್ಗೆ ಎದುರುಗಡೆ ಲಾಯರು. ದಟ್ ಶುಡ್ ಬಿ ಅಡ್ವೊಕೇಸಿ. ನಾನು ಬಂದೆ ಓದೆ ನೋ ಯೂಸ್ ಅವತಾರ ಬಿಟ್ಕೊಂಡು ವೈ ಫೇಲ್ಯೂರ್ ಲವ್ ಫೇಲ್ಯೂರ್ ದೆನ್ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನೀಟಾಗಿ ಬರ್ಬೇಕು ನಮ್ಮ ಕೋರ್ಟ್ಗೆ. ವಿ ಡೋಂಟ್ ಲೈಕ್ ದಿಸ್. ಲಾಯರ್ ಅಂದ್ರೆ ಲಾಯರ್ ತರ ಇರ್ಬೇಕು. ಅದೆಲ್ಲ ಫಿಲಿಮ್ ಅಲ್ಲಿ ಮಾಡೋದು ಸ್ಟೈಲ್ ಗಿಲ್ ಎಲ್ಲ ಹುಡುಗಿರ್ ನೋಡ್ಲಿ ಅಂತ. ಇಲ್ಲಿ ಯಾರು ಹುಡುಗಿರ್ ನೋಡಲ್ಲ, ಬರೀ ಕಾನೂನು. Yes. Yes. Yes, sir. Yes, sir. I could go submit the Inspector of Communication. I could not respond it. Submit the Anil Kumar for Tahsildar land. I'm getting back. I will complain the order or not. Or cut on Amyan. We don't like call any person to see their good faces, sir, unless they comply.
ವಾರಂಟ್ ಇಶ್ಯೂ ಆಗಿತ್ತು ಆಗಿಲ್ಲ ಇವಾಗ ನಾನು ಲೀವ್ ಅಂದ್ಬಿಟ್ಟು
Yes.
Yeah, 3 months.
2 months. Into this. 967. Read the order page 17. That is submission made by Leonard government. "90 days from 8/3/2019. When did you receive the receipt copy? Petition copy. All. Correct. 23/19. Alinda 90 days. ಯಾವಾಗ ಆಗುತ್ತೆ?
21.
Huh? 21 June. You have to comply. 21 June 2019, you have to comply. Now we are ಎಲ್ಲಿದೆ? ಏನ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್? ಏನ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಅಪ್ಪ? ಪ್ರೊಸೀಡಿಂಗ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಂತ ಹೇಳಿದ್ದಾರೆ. There is endorsement. Just show proceedings disposed of. Where is that? When? When, sir? 15? After how many years? How much will impose cost on the Tahsildar? He has to pay from his pocket. He can't take the court order lightly. Enjoy. And when issued, government advocate summoned him, you don't care. Issue warrant, you don't available. That is not a. It's all right, no problem. You don't want that. Now we have closed only on 15/11/2022 proceedings. When you closed 15/11/2022, how can you issue endorsement 10/10/2019? Who asked you to issue endorsement? Mr. Arun, please read the order properly, understand and answer. The general, like, don't argue like your Tahsildar. Then where is the endorsement? For what purpose? Sir, read the order. Read para 9 of the order. Steps are by the coordinate bench. ಕೇಸ್ ಲಿಸ್ಟ್ ಮಾಡಕ್ಕೂ ಒಂದು ಆರ್ಡರ್ ಬೇಕು ನಿಮ್ಗೆ. ಆಮೇಲೆ yes. Para 11. Accepting the aforesaid submission.
These restrictions are allowed. Responding to the
Directed dispose of the proceedings LND NA CR 84 to 1718 in accordance with law within 90 days. He has to dispose of only the proceedings. He has no business to issue endorsement. What is the endorsement? What is the endorsement? This is 2017 order passed by this court, a single judge of this court, where a direction was issued to register the case was registered. Then the earlier order was passed, has not passed the order, confirmed by the coordinate bench, not passed the order. Again, fourth time he has come before this court. Proceedings start ಮಾಡಿದ್ರೆ ನೀವು ಒಂದು endorsement. You want to generate the litigations. The Tahsildar meant for generating the government litigations more, or to do the government job honestly. Ask him how many years his experience as Tahsildar, promoter, direct Tahsildar. This order was passed on 19. You are there. Who was the earlier Tahsildar? He is Anil Kumar. Let the Manjunath also come. We will impose cost, heavy cost. Let them pay, distribute equally, and pay personal package. They are playing with the court. Who passed this order? The latest order passed by whom? 15/11/2012. R1. When did he took charge?
19 September 2020.
19 September 2022. He implied the other Manjunath also. ಎಲ್ಲಿದೆ ಅವ್ರ ಇದನ್ನ ಅಮೆಂಡ್ ಮಾಡಿಸಿದ್ದೀನಿ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ ಆರ್ಡರ್ ಡೇಟ್ 17/11/2022 Manjunath rounded back and Anil Kumar will impose cost both on the Tahildars. Ask him, let him, you want to pay, let him pay from his own pocket, or you want to collect from Manjunath, you can collect. We can't tolerate this type of ಇಷ್ಟ ಬಂದಾಗ ನೀವು ಮಾಡ್ತೀರಾ ಏನು ಕೋರ್ಟ್ ಒಂದು ಹೇಳ್ ತಿಳ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಿ. We're imposing costs for closing the proceedings. You and the other person has to pay. What for? Really, what for? What's the kata? You want to create one more litigation. Mr. Court proceedings is proceed, close the proceedings, L&D proceedings. Where is the endorsement? You are going against the order. Court says final order, you says endorsement. And the judge has to challenge your order. Who has to challenge? Then what is mean by who has to issue endorsement, sir? That is a per se contempt. We'll take two more contempt. You see, we'll insert two more contempt against these two people. You see, nothing but you daring raid on the court. When the court says you dispose of the L&D, you issue endorsement. Against the court, this amount contempt. We'll insert read to see. Criminal contempt, sir. We'll insert criminal contempt against these people. Who issued this endorsement 10/10/19? Get him. We'll insert criminal contempt against these people. They play with the courts. Bama. A reasonable cost, ask him. Reasonable cost as to he has to pay from his pocket. If you don't pay, we'll say collect from his salary, and we'll include this payment of fine should be endorsed in the service records. What no andre you Supreme Court ತಗೊಂಡೋಗಿ ನೋಡೋಣ no ಅಂತ. What do you mean by no, sir? The willfully violating the order passed by learned single judge, you said no. Ask him. Yes, how much cost you have to pay? 1 ವರ್ಷ 1 ಲಕ್ಷ. (2019) we are 2022. You just playing with the courts. At least you know what is meant by order. ಕೇಳಿ ಅವರಿಗೆ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಏನೋ ಗೊತ್ತಾಗುತ್ತೆ ನಿಮ್ಗೆ ಅಂತ. ಯಾವಾಗ ಬೇಕಾ ಮಾಡ್ಕೋಬಹುದು. ಜನಗಳು ಬರ್ತಾರಲ್ಲ ನಿಮ್ಮ ಆಫೀಸ್ಗೆ, ಅವರು ಅಲ್ದು ಚಪ್ಪಲಿ ಅಲ್ದೋಗುತ್ತದೆ ಖಾತಾ ಮಾಡ್ಸಕ್ಕೆ. ಹಂಗೆ ಕೋರ್ಟ್ ಅವ್ರು ಅಲ್ದು ಮಾಡಿ ನೋಡೋಣ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತ. is using same principle, Article 14. The litigant as well as the client, the court appreciate his guts. We are not concerned assuming charge. So done immediately. Then if that is your answer, then we will summon the Tahsildar. Manjunath will summon, initiate criminal proceedings against both these people. Per se criminal contempt. Read to see. Odi. Mr. At the other side, the earlier Tahsildar issued endorsement. Why you have deleted? You should have been included this man, that man, both. ಅವ್ರು ಹೇಳ್ತಾರೆ ಅವ್ರು ಚೇಂಜ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಅಂತ ನಾವು ಹೇಳ್ತೀವಿ ನೀವು ಅಬ್ಸರ್ವ್ ಮಾಡ್ಬೇಕು ಅವ್ರು ಹೇಳ್ತಾರೆ ಚೇಂಜ್ ಆಗ್ಬಿಟ್ಟು ಸ್ವಾಮಿ ಅಂತ ಎಸ್ ಸರ್ ಯು ಹ್ಯಾವ್ ಟು ಟೇಕ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಯು ಹ್ಯಾವ್ ಟು ಪೇ ಹೋದ್ರಿ ಟೂಸಿ
By words, spoken or written, or by signs, or by physical representation, or otherwise, any matter or the doing of any other act whatsoever, which vandalizes
is standardizing the court order by issuing endorsement. Will insert contempt against these two people. Will insert contempt proceeding will stall. This is amount perjury. Will take some more contempt, sir, against these people. Perjury supplied insertion. Not these people. They are not unfit to continue in the state department, revenue department. These people, they are under impression, become Tahsildars, license for everything. They should work honestly to their conscience. Not only they get the salary, they get other things. They are meant for that. And they are willfully disobeyed court order. They don't care court order. Now we'll see. Yes, ask him what is cost. Are you in charge contempt criminal proceedings? Ask him contempt or criminal proceedings, both against both. Reasonable cost 3 ವರ್ಷ ಎಷ್ಟು ಹಾಕ್ಬೇಕು ಹೇಳಿ. If he is in possession of the applicant, if he was dragged from 2015 till today, 2017 till today, ಅವ್ರಿಗೇನು ಲೆಕ್ಕಕ್ಕೆಲ್ಲ ರೀ 16 3 ವರ್ಷ ಒಂದೊಂದು ವರ್ಷಕ್ಕೆ 20-25 75,000 13 ಪೇಪರ್ ಮಿಸ್ ಪಾಕೆಟ್. ಹಾ ಹೇಳಿ ಎಷ್ಟು ಪೇಪರ್ ಮಿಸ್ ಪಾಕೆಟ್, ನಾಟ್ ಫ್ರಮ್ ದಿ ಗವರ್ಮೆಂಟ್. ಈ ಕಲೆಕ್ಟ್ ಫ್ರಮ್ ದಿ ಮಂಜುನಾಥ್ ವಿಲ್ ಅಬ್ಸರ್ವ್ ಬಾಮ. The present contempt petition is filed by the complainant to take action as the accused for willful disobedience of the order dated 8/2019, made in WP 8819/88/2019, wherein the learned single judge observed that pursuant to the order passed by the coordinate bench dated 12/7/2017 in WP 39/261/2010 and 39/656/2010, the Tahsildar appeared before the petitioner appeared before Tahsildar on 5/7/2017, and case was registered as LND/NA CR 84/2017-18. The grievance of the petitioners before the learned single judge that despite the representation dated 7/3/2018 made by them to the respondent to complete the proceedings as per the order passed by the remand order passed by Special Deputy Commissioner, confirmed by coordinate bench, the respondent has not concluded these proceedings till the date of filing the present petition. The present petitions, first off, on the concession made by the learned additional government advocate that if sufficient time is granted to the respondent Tahsildar he would dispose of the proceedings LND stroke NA CR 84 to 1718 on merits in accounts with law. Accepting the said submission of learned AGA, writ petitions are allowed. The Tahsildar Bengaluru North Taluk within the Additional Taluk, Bengaluru, was directed to dispose of the proceedings LND stroke NA CR 84 2017-18 in accordance with law within 90 days from the date of certified copy of the order. Since the then Tahsildar Manjunath and present Tahsildar Anil Kumar are not compliant, thereby the accused was forced, the complaint was forced to file the present contempt petition on 28/2019. Full stop. Today, the learned government advocate first time filed the complaints affidavit dated 28/11/2022, filed by Anil Kumar, Tahsildar Yalanka, Bengaluru North Taluk. In the affidavit, he has stated that the certified copy was communicated to their office on 23/19. Thereafter, fresh notice was issued to all the interested parties in respect land in question, and proceedings were conducted on priority basis. It is further stated in the year 2019, an endorsement dated 10/10/19 was issued to the complainant, categorically asserting as the grievance of petitioner, complaint has been adjudicated. Thereafter, by quoting the endorsement, the opposite LND proceedings also been closed on 15/11/2022. Thereby, the order for nursing has been complied. First up, when the learned single judge on concession made by learned government advocate directed the Tahsildar to dispose of proceedings in accordance with within 90 days from the date of issue of copy of the order. According to Tahsildar, receipt of the order was on 23/19. Should have been disposed of 90 days within on or before 21/6/2019. Full stop. Very strangely, though the learned single judge directed to dispose of the proceedings within 90 days, very strangely, the then Tahsildar, by endorsement dated 10/10/2019, issued that there is not possible to do PODI. To stop. The endorsement is nothing but per se contempt. When the court directed dispose of the proceedings, the Tahsildar has no business deviate the court order and issue endorsement, summons to criminal contempt as contempt section 2C of the Contempt Court Act proceedings. Full stop. The fact remains that the Tahsildar has to dispose of proceedings on or before 21/6/2019 within 90 days from 23/2019 on the day he received the certified copy of the order of single judge, very strangely, after the contempt proceeding is initiated, now the Tahsildar opened his eyes, close the LND proceedings only on 15/11/2022. Thereby almost delay of 3 years, 5 months. Thereby, the attitude of the then Tahsildar Manjunath and the present Tahsildar Ravi Kumar, Anil Kumar, is nothing but harassment to the litigant who approached the court in the 2017, and now the order is passed only on 15/11/2022. Is nothing but daring raid on the court when this court directed to dispose of the matter within 90 days ought to have done on 21/6/2019. First off, thereby the complaint was driven before this court by filing present contempt petition on 23/8/2019, implementation of the order of learned single judge by spending litigation expenses, mental trauma on financial loss. Now, after issue notice by this court in the present contempt of passing order on 15/11/2022, now the endorsement issued only on 15/11/2022. This clearly indicates that the accused persons, present accused and the previous Tahsildar Mannath had no respect for the court order, unnecessarily deviated the proceedings and dragged the matter. Thereby, the respondent accused persons who are working under the state government unnecessarily creating the litigation and thereby harassing the general public, which is not the intention of the order passed learned single judge or the fraudulent contempt of court proceedings. Thereby, though both the present Tahsildar and the previous Tahsildar are liable to criminal contempt, the Anil Kumar learned government pleader assured the court these two persons never disobey the court order in future on the undertaking given by the Anil Kumar before this court. He persuaded not to initiate criminal proceedings. As now the order of learned single judge at last complied on 15/11/2022. Therefore, he submits reasonable cost may be imposed. First of, though we are inclined to impose 1 lakh each on the Tahsildar, Didan Tahsildar Manjunath and present Tahsildar, we are persuaded by learned government pleader to impose the reasonable cost of 50,000 of litigation expenses by driving the complaint before this court, filing the present contempt petition on 23/8/2019, engaging a lawyer for mental trauma, and ultimately no relief is granted by the accused person to the accused person to the complaint. First up, at last, the order of learned single has been complied on 15/11/2022, more than 3 years, 5 months. Thereby, the present accused is liable to pay the cost of ₹50,000 as litigation expenses. Present contempt proceedings. First up, in of the above, we pass the following order. We'll say this order will send it to this authority to enter the service records. We'll send this order to the revenue secretary to enter the service records. You harass the people, or younger mans barte, or yana atma sakshi dan keli. The contempt proceedings are hereby dropped, except a delay of 3 years, 5 months in complying the order of learned single judge, subject to cost of payment, subject to payment of cost of ₹50,000, payable by the Tahsildar from his pocket and not from the government, to the complainant within a period of 3 weeks, failing which the office director to post the matter to take action against the accused under the power subsection 12 of the Contempt Court Act. Accordingly, further. Since we observed that both the Anil Kumar and Mannath are thus delaying the proceedings and harass the litigant and abuse the process of this court, the order dated 15/11/2022, 17/11/22 passed by this court is recalled, including warrant issued to to the present accused. All right, accept in the, is all allowed. A contractually, he should say both Manjunath and Anil Kumar, contractually, amend the contract. Yes. The present accused is also permitted to recover 25,000 rupees from the previous Tahsildar, Manjunath. Yes. Yes, Chaudhary. Where is that? Read. Or copy kodi. Read. Yes, sir. Read the order, sir. Now they have filed approved, they are not violated status quo. Now they have filed not a alienate. That is the order. Huh? That is modified.
Oh, no.
Mr. Counsel, read their affidavit. First order is status quo. Subsequently, the Honorable Single Judge modified the order. Page 11. Parties are directed to maintain status relating property in question until further orders. He says, this order was passed by Learned Single Judge on 15/2019. Subsequently modified on 7th February 2019. First to not to alienate. ಆಮೇಲೆ ಆಗಿರೋದು. First to not to alienate the order. All right.
Came on record. Sort of modification.
Minus status quo. From 15/19, you are not doing anything. Too close. Sir, ಅವ್ರು ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ನೀವು ಮಾಡಿದೀವಿ ಅಂದ್ರೆ ಅದಕ್ಕೇನು ಮೆಟೀರಿಯಲ್ ಇಲ್ಲ. This court cannot hold enquiry. ಏನ್ ಮೆಟೀರಿಯಲ್ ತೋರಿಸಿ. ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಯಾವಾಗ ಕೊಡ್ಬೋದು ನೀವು ಅದಕ್ಕೆ ಅಂತ. Police acknowledgement is not a document. Show of photographs data ಇಲ್ಲ ಇದಕ್ಕೆ. After 15/9/2019, where they are doing ಅದೇನೋ ಅಲ್ಲಿ ಫ್ಯಾಕ್ಟ್ ಓಡಿಸ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ. What is the violation, sir? ಏನು ಎಲ್ಲಿ dates? We don't know. These are all old policies. After the order dated 15/2019, I have not done anything. We record that to close the matter. If she still proceed, matter pending before Learned Single Judge. Go before Learned Single Judge directly. All right. Here, you have to file a press contempt, not reopen. Bama. The present contempt petition is filed by the complaint to insert contempt proceedings against the accused under provision of section 11-12 Contempt Court Act for willful disobedience of the order dated 15/2019, made in probate company 15/2017 connected matters, wherein the learned single judge directed both the parties maintain status quo while issuing the interim modifying the earlier order dated 7/2019. Both the parties maintain status regarding property in question until further orders. And matter is still pending. Before the learned single judge. The complainant, the accused filed the affidavit dated 29/11/2022 in paragraph 4 and 5 specifically stated as under. 6 also as under. First up, the learned counsel for the complaint submits if the contempt proceeding is closed, he will further violate the order for learned single judge. If any further violation, it is always open for the complainant to file a press contempt petition, or you can brought to notice of learned single judge where the matter is pending between the parties. In of the above, we pass the following contempt proceedings are be dropped as the order maintains status quo still existing between the parties. Parties have to maintain status quo. If any one of the parties violates, it needless to it is always open for the either of the parties to approach this court by a press contempt petition. Yes, Ranjit. Fifth time, pass out. Allah Podi. Ma, yes. Madam so and so submits. Madam so and so for the complaint submit needful to be done during the course of the day. Submission plus on the card after check them proceed. Yes. 1 week time is granted to comply with objections. Yes, Rajendra. ಏನಕ್ರಿ 10 ದಿವಸ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಇರ್ತದ್ರಿ ಅವ್ರು ಗೌರ್ಮೆಂಟ್ ಅವರೇ ಮಾಡ್ಬಿಟ್ಟಿವಿ ಏನಿರ್ತದಪ್ಪ ಜಸ್ಟ್ ಗೋ ಟು ದಿ ಇದು 10 ನಿಮಿಷ ನಿಮ್ಗೆ at the request of Sri Vijay Learned Counsel was appointed as amicus curiae to court 6th time next week. Ali, office to show the name of Vijay under of the complainant. My evidence alakri, then object change ಬೇಕಾಗಿಲ್ಲ. For this matter, evidence or change ಮಾಡಿಲ್ಲ ಇನ್ನಲ್ಲ ಅವರ ಹಂಗೆ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ಅವಳೆಲ್ಲ ಬೇರೆಯವ್ರು ಬಂದು ಅದನ್ನ ಫಾಲೋ ಮಾಡ್ಬೇಕು, ಇದನ್ನ ಕಂಟೆಂಪ್ಟ್ ಮಾಡ್ಬೇಕಾ? ನೀವು ಕರ್ದು ಕೊಡು, ನೀನು ಓಪನ್ ಆಗಿ ಎಲ್ಲರೂ ಕೊಟ್ಬಿಡು. ಆರ್ಡರ್ಸು ಐಎಗಳು ಮತ್ತೆ ಫ್ರೇಮಿಂಗ್ ಆಫ್ ಚಾರ್ಜು, ರೆಕಾರ್ಡಿಂಗ್ ಎವಿಡೆನ್ಸ್, ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಆ ತರ ಅಂತ ಅವ್ರಿಗೆಲ್ಲರೂ ಕೊಡು, ಕರೆದ್ಬಿಟ್ಟು ಸೆಕ್ಷನ್ ಫುಲ್ ಕರೆದ್ಬಿಟ್ಟು ಒಂದೇ ಸರ್ ಇಲ್ಲ ಕರೆದ್ಬಿಟ್ಟು ನಾವೇ ಹೇಳ್ಬಿಡ್ತೀವಿ ಎಲ್ರಿಗೂ. ಅವಳಿಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೊಬ್ರು ಬರ್ತಾರೆ. ಯಾವ ಟು ಫಾಲೋ ಸರ್. ಒಂದು ವಾರ ಆಯ್ತು ನಾವ್ ಹೇಳಿ. ಇಫ್ ದೇ ಕಂಟಿನ್ಯೂ ದಿಸ್ ಆಟಿಟ್ಯೂಡ್ ನಾವು ವಿಲ್ ಇನ್ಸೈಡ್ ಸುಮಾಟ ಕಂಟೆಂಟ್. They are not listening to court observations. Tercely, all section. Yes.
My lord, I appeal for the respondent institution. My lord, I have filed an affidavit, my lord, stating that we have not collected any amount. In the meanwhile, my lord, your lordships have disposed of the writ petition itself by directing us to refund the amount along with interest that we are paying, my lord, as per the lordship's order.
Paid, not paying.
ಅಲ್ಲಲ್ಲ, ತಾವು ಫೈನಲ್ ಆರ್ಡರ್ ಮಾಡಿದಿರಿ.
ಅವ್ರು ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲಲ್ಲ, ಇದು ಅಗೇನ್ಸ್ಟ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್, ಮೈ ಲಾರ್ಡ್.
ವೆದರ್ ಫೈನಲ್ ಆರ್ಡರ್ ಕಂಪ್ಲೈಂಟ್.
ಪಾರ್ಡನ್, ಮೈ ಲಾರ್ಡ್.
Whether the
ಅಲ್ಲ, ಅದು
final order,
ಅದ್ರ ಮೇಲೆ ಕಂಟೆಂಪ್ಟ್ ಇಲ್ಲ ಫೈಲ್ ಮಾಡಿಲ್ಲ. ಇನ್ನ ಟೈಮ್ ಇದೆ ಕೊಡೋದಕ್ಕೆ.
You are waiting another contempt file ಅಂತ ಮ್ಯಾನೇಜ್ಮೆಂಟ್. What type of
ಅಲ್ಲ ಕಂಟೆಂಪ್ಟ್ ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ಮೇಲೆ 15 days from the date of receipt of the order ಅಂತ ಹೇಳಿದ್ರಿ. ಲಾಸ್ಟ್ ವೀಕ್ ಸಿಕ್ಕಿದೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ. ಐ ಹ್ಯಾವ್ ಫಾರ್ವರ್ಡೆಡ್ ಟು ದಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್, ಮೈ ಲಾರ್ಡ್.
ಎಷ್ಟು ಮಿಸ್ ಅಜಯ್? Now you have passed the final order.
Yes.
You have to comply. You don't comply, come back. ಇದು ಕ್ಲೋಸ್ ಮಾಡ್ತೀವಿ. ಅದೇ ರೀ, ಇದು ಎಂಟ್ರಿ ಮಾಡಿದ ಮೇಲೆ ಫೈನಲ್ ಆರ್ಡರ್ ಬಿಕಮ್ ಇನ್ಫ್ರಾಕ್ಚರ್ಸ್. These are liberty to you. Liberty to you. If they violate, come back. ಅವ್ರು ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ. ನಾವು ರಿಕ್ವೆಸ್ಟ್ ಇಲ್ಲ, ದಂಡಂ ದಶಂ, ನೋ ರಿಕ್ವೆಸ್ಟ್. ಇವತ್ತೇ ಡ್ರಾಪ್ ಮಾಡ್ತೀವಿ. ಲಿಬರ್ಟಿ ಟು ಯು. ಇಫ್ ದೇ ವೈಲೇಟ್ ದಿ ಫೈನಲ್ ಆರ್ಡರ್ ಅಷ್ಟೇ ಹಾಕಿ. ಒಂದ್ವರಿ ಕೊಡೋದಿಲ್ಲ ಅಂದ್ರೆ ತಗೊಂಬನ್ನಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್. ಇದು ಸಂಬಂಧ ಇಲ್ಲ ಮಿಸ್ಟರ್ ಅಜಯ್. ಅದು ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಸಪ್ರೇಟ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಇದ್ರಲ್ಲಿ ಬರಲ್ಲ. ಅದು ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇಫ್ ದೇ ಹ್ಯಾವ್ ಗಟ್ಸ್ ಲೆಟ್ ದೆಮ್ ಗಿವ್, ವಿಲ್ ಸಿ. ನಾವು ಅದರಲ್ಲಿ ಕಾಸ್ಟ್ ಹಾಕಿದೀವಿ 6% ಕೊಡ್ಬೇಕು ಅಂತ. ಎಸ್, ಯಾರು ತಪ್ಪಾದ್ರೆ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿ, ಅವರು ಚಾಲೆಂಜ್ ಮಾಡಿ, ನಾವೇ ಏನಿಲ್ಲ. ಇದು ಅಜಯ್, ನಥಿಂಗ್ ಇಸ್ ದೇರ್, ನಥಿಂಗ್. Do you mean to say keeping contempt ಸಿಗುತ್ತೆ ಇಲ್ಲದೆ ಸಿಗಲ್ಲ ಅಂತ ನೀವು? Let us see. You want to test these people. You said, I want to test these people. We'll close this matter. We'll test these people. If they violate, then we'll see. Mama, I'll record a submission. ಅಜಯ್, ಅನ್ನೆಸೆಸರಿ ಒಂದ್ ದಿವಸ ಬರ್ಬೇಕು, 6,000 ಖರ್ಚು ಬರುತ್ತೆ ಸರ್ ಕೋರ್ಟ್ ಮುಂದೆ. ಪೆಂಡಿಂಗ್ 6,000 ಫಾರ್ ಈಚ್ ಕೇಸ್ ಸರ್. ಈ ಸೆಟ್ ನನ್ನ ಕಾಪಿ ಕಳ್ಸಿದ್ದೀನಿ, ಇಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ರೆಕಾರ್ಡ್ ಸಬ್ಮಿಷನ್ ಮಂಡಲ ಫೈಲ್. Yes, Mr.
My lord, this contempt has to be dismissed with cause, your lordship. Your lordship, from the beginning, my lord, he has not been able to point out what is the contempt we have committed. I don't understand, my lord, why my lord should argue this case in this vehemently. That is a separate cause of action. I have told them they are processing, they are calculating the amount, they are paying. But that has nothing to do with this contempt.
But worry, sir. Sir, let us not speak. Let us work with pen. Wait. The present contempt proceedings filed by the complainant against the accused persons to take action against the accused under the clause of Section 1112 Contempt Court Act for full disobedience of the interim order dated 13/8/2019 made in WP 47299 304/18. To stop, Sri Ajay Kumar learned counsel for the complaint and Sri Gole Chandrakant or Gole learned counsel for accused 1 and 2 submits that the final order came to pass in WP 47299 304/18 by this court on 28/9/2022. To stop, the said submission placed on record. It is needless to observe, if any of the parties violates the order passed by the court, final order passed this court dated 29/2022, it is always open for the aggrieved party to file a press contempt proceedings. In the above for the following order, contempt proceedings are a draft.
Much okay.
28/9 September 9th ತಾನೆ 28/9. Yes. Mr. Gowla, don't give room for another contempt.
Definitely not, my lord. Definitely
Yes.
not. I have already warned them.
Yes,
Told
yes,
them
yes.
to comply. They are calculating the amount, my lord. They would be paying shortly.
All right. Yes, Govindraj. Where is the accused? IAT has been filed, recall in this so and so. What accused? Accept so and so, counsel for this so and so. Last chance, 1 week time is granted. Current counsel for accused charge. Where is the counsel, sir? Eleni Prendo. Complaint is ready. Hello, where is the complainant? One sala pass on mana. Another warrant. Wait. Also, none appears for the counsel for the accused. Also, Raspati, Rajendra. Yes, what is this? Finally, 1 week time is granted at the request of local counsel for the complaint to comply the order so and so. I submit whether the name of the complaint is reflected in the RTC even prior to the order for deputy commissioner. Yes, sir. Padi. Your name was reflecting on 26/5/2015 in the RTC.
Not very near, but enter the name of the government. Removing the name of the private individual. Not the name of the Supreme Court or the name of the private individual. In this case, not that actual article, I don't know.
ಅವನ್ ಬರ್ರಿ ಎಲ್ಲಿದೆ?
That is not the issue. They want the name of Maharaja of Parliament.
Yes.
That is the only one.
Yes, sir.
Very contention resided in the litigation board. Whether these properties are private properties of Maharaja under the agreement of accession for so date. Now the categorical finding is recorded by the government. According to the that is also these are items government other
Aramane Kavul belongs to government. Then you are showing ego. Read 161. Set aside. Next. No, consider making appropriate entries in the name of the petitioners. Where is the representation, Mr. B? 161B.
the direction is for entering the names of the petition.
Upon the representation
Now the
of what? You Kodi representation Kodi. You representation.
Representation is not. Still first coming from
ದಯವಿಟ್ಟು no, Mr. Senior Counsel, please come to 161. Order of possible understanding. ಆದ್ಮೇಲೆ ಯಾವಾಗ ಕೊಟ್ಟಿದ್ರೆ ಹೇಳಿ representation.
the ಆದ್ಮೇಲೆ representation ಕೊಟ್ಟಿದ್ದೇವೆ ಈಗ
ಹಿಂಗಿಲ್ಲ. Revenue authorities, municipal authority consider making appropriate entries in the names of the petitioners upon represent being made in accordance with law. After the order, where of the representation, enter my name.
but you would
No, Mr. Annexure D, you have issued representation Tahsildar to issue kata. That is not the issue. ಅಲ್ಲಿ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಆರ್ಡರ್ ದಯವಿಟ್ಟು ಓದಿ, ಅದಿದ್ರೆ ಅಲ್ಲಿ ಕೊಡಿ. ನೀವು ಹೊಸದಾಗಿ ಏನೋ ಹೊಸ ಡಿಸ್ಪ್ಯೂಟ್ ಅಂತ. That is not the order. When the judge says, consider upon the representation, your name. ನಿಮ್ ಬರ್ಲಿ, ಆಮೇಲೆ ಏನ್ ಬೇಕಾ ಮಾಡ್ಕೊಳ್ಳಿ.
ನಮ್ಮ ಹೆಸರು
ನಿಮ್ಮ ಹೆಸರು ಬರೀ ಅಂತ ಹೇಳಿ ಆಮೇಲೆ ನೋಡೋಣ.
All they have to do is give a representation. Consider the representation.
Leaving it open to us to approach again, because they are not going to do
The
it.
learned government advocate pointed out that in terms of the order for learned single judge, paragraph 8, Roman.
Now, paragraph 161.
Roman 7(2)(b). The revenue authorities, municipal authorities to consider making appropriate entries in the names of petitioners upon the representation being made in accordance with law as per the applicable procedure in the light of the findings made thereunder. The complainant has not made any representation to enter the name of the complainant. Thereby, if representation is made, the authority will consider pass appropriate orders in terms of order for single judge.
Not be there.
Next week, the Learned Senior Council, Sri Jacob Patil submits, the representative will be made within a week from today. And thereafter, the authorities shall consider the representative pass appropriate within a week thereafter. Within 2 weeks thereafter, all the matter up to 3 weeks. Yes. ಇದೆಲ್ಲ ಯಾಕ್ರಿ ಹರಾಸ್ ಮಾಡ್ತೀವಿ ಜನಗಳಿಗೆ ನೀವು? No, we are observing you are actually become a litigant. Government become litigant in all the cases for no use, only for fighting. All the cases you are just fighting for sake of fighting. All they are your children, sir. Should act like a mother. You can't act like a China and Pakistan. No, it's unfortunate. In every case, you just harass the people. ಅದೇನ್ ನಿಮ್ ಖುಷಿನೋ ಗೊತ್ತಿಲ್ಲ, ನಿಮ್ಗೆ ಖುಷಿ ಇಲ್ಲ, ನಿಮ್ಮ ಆಫೀಸರ್ಸ್ ಖುಷಿ. ಅದ್ ಯಾಕೆ ಹರಾಸ್ಮೆಂಟ್ ನಮ್ಗೆ ಗೊತ್ತಿದೆ. ಅದು ನಮ್ಗೆ ಹೇಳಕ್ ಆಗಲ್ಲ, ಒಂದ್ಸಲ ಇದಿಲ್ಲ ಒಂದ್ಸಲ ಹೇಳ್ತೀವಿ. Yes. Yes, Javed. ಏನೋ ಪಾಸ ಬಿಸ್ನೆಸ್. Okay. ಒಂದು 11% of the Mr. Leeladhar. You are paying for whom? Oh, you have appointed, yes, yes. 211. Yes. Vikram. Yes, Madi. Piero. ಏನು ಹಂಗೆ ಹೇಳ್ದಾಯ್ತು ಬಿಡ್ರಿ, ಕಾಪಿ ಕೊಡಿ, ಇದು ಕೊಡಪ್ಪ. Opinions on order on. No cost of account. Yes, sir. Well, the message. I'm the complaint in the above contempt petition. Ali, examiner in chief by Vikram. Munni Rajgopal. You have the complaint. Yes. Kelly. I'm the complaint in the above case. My age is about 55 years. I know the facts of the case. Yeah, exactly. I have filed Form 53 before the Tahsildar. For what? For grant of land. Where? Survey number L3. Survey number 50. 55 750 of Achareddy village. Achareddy village, Anabal Hobli, Saklashpur Taluk. Yen Mardu Idmal Landra. Tahsildar has not disposed of the said application. Thereby I have filed WP 12/5/12/2021 before this court. Yenaito? ಆದೇಶ ಯಾವತ್ತು ಆರ್ಡರ್ ಆಗಿದೆ ಯಾವತ್ತು on 13/7/2021 this court the launching of this court directed Tahsildar Sakleshpura to dispose of the application within 8 weeks from the date of receipt of certified copy of the order. In the meanwhile, directed both the parties maintain status quo. With regard to portion of 1 acre 20 kuntas in survey of 50 of Achareddy village, Anaval Hobli, Sakleshpur Taluk, Assam district. Adnalako. In spite of the order passed by this court, the accused person, yaar bandito? The first accused number 1 came to spot along police on 14/7/2021. Yaar madru? Removed the coffee plantations and other trees in the land in question. Accordingly, they have taken photographs of the same and communicated by lawyer. Yavaga, our lawyer sent the SMS to the accused on the same day. Yes, time, same day, that is on 14/7/2020. What time? about 11 AM. Yes.
So, contempt is
I filed present contempt petition against the accused who violated the order passed by the Learned Single Judge and removed the plants in the land in question. Yes, yes, I pray. The accused may be punished in accordance with law. What is the document? ಯಾವ್ದು ಮಾರ್ಕ್ ಮಾಡ್ಬೇಕು ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಏನಕ್ಕೆ ಮಾರ್ಕ್ ಮಾಡಿ ವಾಟ್ ಯು ವಾಂಟ್ ಮಾರ್ಕ್ ಸರ್
Give the list of documents.
ತೋರಿಸಿ ಅವ್ರಿಗೆ ತೋರಿಸ್ಬಿಟ್ಟು ಹೇಳಿ The certified copy of the order passed by the Learned Single Judge dated 13 July 2021, marked as Exhibit C1. ಅದೇನ್ ಬೇಕಾಗಿಲ್ಲ ರೀ ಆರ್ಡರ್ ಏನಕ್ಕೆ ಬೇಕು ಮತ್ತೆ ಆರ್ಡರ್ ಪಾಸ್ ಬೇಸ್ ಆನ್ ದಟ್ ಆರ್ಡರ್ ವೈ ಯು ರಿಲೈ ಅಪಾನ್ ಬೇಕಾಗಿಲ್ಲ ಥರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ಅಬ್ಜೆಕ್ಷನ್ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ any objection to mark the paper publication marked paper publication marked subject to objection other side as exhibit C2. Yes.
There are two affidavits.
E contempt alle. It's a part of record only mark. All right. The counter affidavit filed by the accused on 22nd December 2021, certified copy of the counter affidavit filed marked as Annex C3. Innondu further compliance affidavit of the accused dated 22/9/2022, certified copy of the further compliance affidavit filed in the present contempt petition is marked as C4.
Exceptions that were set by the advocate.
Illegal.
Give the contempt petition. Yeah, I'm finding the 65 year of the advocate also.
Annexure
Annexure G.
ನೀವು ಮಾಡ್ತಾರಲ್ಲ all right. Annexure G, SMS sent by the learned advocate to appear for the complainant on 14th July, hours 2021 at 12:12 PM. Marked as Annexure C5. Yes. ನೀವು ಗಾಬರಿ ಪಡಿಸಬೇಡ್ರಿ ಅವ್ರಿಗೆ ಮಾಡ್ತಾರೆ ಅಲ್ಲ ಇನ್ಯಾರು ಮಾರ್ಕ್ ಮಾಡ್ಬೇಕಪ್ಪ ಯಾವ ಫೋಟೋಗ್ರಾಫ್ಸ್ ವೇಜ್ ನೆಗೆಟಿವ್ಸ್ ವಿತೌಟ್ ನೆಗೆಟಿವ್ ನಾಟ್ ಅಲೋ ಸಿಡಿ ಮಾರ್ಕ್ ಮಾಡಿ
Apologies, I have only one copy.
All photographs contain the CD.
All of them are there.
Annexure E, E1, E2, E3, up to E6 are photographs.
F and F2.
And F1 to up to F1 photographs and F2. Here the board. Here is board. Oh, F2 is board. Some board. Marked as annexure C5, C5, C6, C6, 1, 2, 3, 6, C6 series. And the said photographs contained the original CD produced as C7. Yes. Don't give left hand, use right hand. To take right, left hand, put. ಒಂದ ಎರಡು ಸೀಟಿಗಳು one set in two sets. CD in two sets, not as so and so. Yes. 40. $65B. ಯಾರು ಕೊಟ್ಟಿದ್ದೀವಿ ಅವ್ರಿಗೆ ಗೊತ್ತು in support of the photos and CD, the certificate by way of affidavit by Uma Mahesh under section 65B of the Indian Evidence Act filed is placed on record. Marked as annexure CD, C8, C7 or 8. 7, yes. CD 7 ಆಗಿದೆ. CD 7 ಆಗಿದೆ. ಇದು 8. C8, yes. ಅಷ್ಟೇನಾ? All right, else place to take action is accused. Witness ಅಲ್ಲಿ. Further evidence, if further evidence of evidence is close. Evidence of CW is close. Further evidence chief of CW is close. The chief evidence of CW2, Ekpil Iladar, Learned Counsel 6 time next week. We request on that day, Learned Counsel, Senior Counsel for the accused, shall examine both CW1, CW2 on that day. Yes. Get ready, how better. 8th, Ravi. 8th. Yes. Yes, correct. ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ ಚಿಪ್ಪಾಗಿ ನೋಡ್ಬೋದು ತಪ್ಪು ಸಪ್ರೇಟ್ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಹಾಕ್ತಿಂತ ಹೇಳ್ತೀನಿ. ಏನು ನಮ್ಮನ್ನ ಆಟ ಆಡ್ತಾರೆ ಅವರು, ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ತಾರೆ. ಆರ್ಡರ್ಗಳಲ್ಲಿ ಇಷ್ಟ ಬಂದ ಮಾಡ್ತಾರೆ. ಸರಿಗಿಲ್ಲ ಪೋಸ್ಟಿಂಗ್ ಹೆಂಗ್ ಮಾಡೋದು ಗೊತ್ತಿಲ್ಲ ಅವ್ರಿಗೆ. ಈಗ ನಮ್ಗೆ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಆಗೋಗುತ್ತೆ ಮಧ್ಯದಲ್ಲಿ. ಅವ್ಳು ಹಾಳಾಗ ಹೋಗಿ ನಮ್ಗೇನಾಗ್ಬೇಕು. ಸರಿ ಅವನು ಇನ್ಚಾರ್ಜ್ ಹೇಳೇ ಇಲ್ಲ, ಇನ್ನೊಂದು ಇನ್ಚಾರ್ಜ್ ಬರಕ್ ಹೇಳಿ. Yes. Evidence on the last. Yes. Who appeared? You are paying for accused number 1 to 3. Madam so-and-so submits that Vivek Valla is retiring for the accused number 1 to 3. And other Sriram Reddy ಇದಾರಲ್ಲ ಅವರು ರಿಟೈರ್ಡ್ ಆಗಿದ್ದಾರೆ. ಸರಿ ಇನ್ಸಿಲ್ ಅವರ ಇನ್ಸಿಲ್ ನಿಮ್ದು PD Surana and takes to file power for the accused number 1 to 3. Office is directed remove the other names of the councils in the card list to avoid confusion, showing the name of PD Surana for accused number 1 to 3 next week. All right, 2 weeks. Yes. Non-furnishing a police report. You are applying for all the accused persons. SLP dismissed. SLP dismissed. Non-furnishing of police report. First, what happened, Mr. SPP? A1. You can take notice. You can take notice for her. Or the party madi. Will implement the latest commissioner, present commissioner. Madam, so and so learner council for the Nandita Adlipur Learner Council for the accused number 3, 4, and 5 submits that the accused number 1, Sunil Bartwal, retired, and now presently Srimati Neelam Shamir Rao, holding the post of Central Provident Fund Commissioner. The said submission of the on record. The petitioner is permitted to amend the cast title accused number 1. You can take notice for accused number 1 also. Madam, text notice for accused number 1. All right, Nandita so and so directed to take notice for accused number 1. 1 and 2 already there. Midi, I'm alone. Do you want to take action? Mele, alone. Served Andhra Pradesh. Accused number 2 served Andhra Pradesh. Yes. Hello, 10 days. The file. Vasudevan. ಏನ್ ಬೇಕಾ ಮಾಡ್ಕೊಳ್ಳಿ ಸ್ವಾಮಿ, ನಮ್ಗೆ ಸಂಬಂಧ ಇಲ್ಲ. ಬ್ಯಾಂಕ್ ಆದ್ರೂ ಮಾಡ್ಕೊಳ್ಳಿ, ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ. We don't know. You are paying for the bank. Is it so? Buyer is ready. Buyer is ready. All right, Thursday. Call the matter on Thursday. Ready? We have given sufficient time in this case. You have shown leniency more than the enough. The learner senior court Vivek Subbareddy submits that today morning the accused had a discussion with the bank manager who is sitting at Cochin yesterday, sitting at Cochin, and buyer is ready to solve the dispute between the parties. Submission just on record. Finally, 1 week time is granted as a last chance, and the accused till today has not deposited 50% amount, so is bona fide. Terms are audited 15/11/2022. Call the matter next Tuesday. The last chance. Yes. Madam, that happened last time also. We're repeating. Not give. Take that. Same. You want again. We're ditching the court. No, ma. We'll issue warrant. Where's your client? You comply or will issue warrant? Will not, just a week will not grant. Last time you are granted. You are not done. What the violation? Yes. We have sold 1 acre 23 guntas. This was admitted by learned senior counsel Mr. Vadewala. Long back, we are given sufficient time. You are not complying, madam. You are not concerned. If you have filed any application, you should have done by this time. Once you said, madam, once you said you have filed application, memo filed, IA filed, you are given sufficient time. You are just playing with the contempt court. You will not return the charge. Call your the accused. Where is the accused? Weeks for what? How many times? What is your name? Sorry. Sorry. Order sheet. Order sheet. We remember this. Manmohan appeared, then Vijayawala appeared. Vijayawala accused, admitted, yes, there is a violation. We granted time to solve the problem. Take it. See the order sheet. How many days? Then understanding again seeking time. It's a misconduct. What's your name?
Ganga.
Ganga. Yamuna Ganga. The madam Ganga, Srimati, Miss or Miss Srimati? Miss Ganga, learned counsel for the accused, seek finally 1 week time for settlement. If any, as her request is acceded, 1 week time is granted for settlement, if any, failing which the accused shall be present before this court to hear and plead the charge. That's why Manmohan is not appearing. Yes, Gunjal. Rido? Gunjal. Amma, keep the time. 30,000 we have spent for both in this matter for reversal. Now we will impose 30,000 for you. Every time if matter was posed before the court, 6,000 you have to spend. This is 5th time. Aidar Muat. 30,000 we already spent by the litigation expenses by the court to government. What's your name? Accepting the apology expressed by the Ankita, learned counsel compliant. Finally, as the last chance, 1 week time is granted. Failing which, post the matter for dismissal next week. We respect your words. If you don't comply, you are not interested. That's all. Yes, Mishra. Why? Why? Not only amended constitution, even the council Even on date, nothing is done, even counsel is not present. You should have said immediately before the court. What's your name, ma? What is your name? Kirtana, what is the violation? What is the direction, ma? Not affect. Read the order. Don't. You are 5 years law student. You are 5th year law student. 3 years. 3 years law student. Please come to page 13. Don't. This is not moot court competition. Whatever you want, say. You read. Respondent post shall consider present petitioner the so and so explain manner in not less than 4 weeks. Consider pass orders. Where the orders pass? Sorry. Yes. Where I stated? Yes, ma, Kirtana. Consider pass the order. We'll recall and we'll dismiss. Recall. We'll recall Ramesh. Kirtana appeared, therefore you are recalling. The present the contempt petition came to be dismissed for default for order for non-amendment of cost type and non-appearance counsel for the complaint. Madam Kitna, learned counsel submits. Who filed the application for recalling? Huh? This is not filed by seniors. This is filed by your party. You are not present. How can you party file affidavit? You should have filed affidavit. The learned counsel, Anup ordinarily filed, the advocate filed the affidavit, explaining the reasons for absence, accepting the cost of the application accompanying affidavit, IA 1 2021, IA delay in furnish source condone, IA 2 2019 to recalling the order dated 18 2019, other by all. First up, the contempt petition restored to the file. Next para. The present contempt petition is filed by the complainant to take action against accused under the provisions of section 11 called contempt court of willful disturbance order dated 19 2018, wherein WP party 4/4/6/2017, wherein the 11th single judge will dispose the petition directed the fourth respondent shall consider the opposite petitioner at annexure L and M to writ petition, expedite manner, and pass upon not later than 4 months from the respect of the order. So, Madam Kirtana, Ms. Kirtana, the learned counsel for the complaint submits, since the accused has not complied, the order for not single judge, thereby the contempt came to be filed on 27 to 2018. The Sri Ramesh, learned counsel for the accused, filed the counter affidavit of T. Ramdas Assistant Revenue Officer, Matikere Subdivision BBMP, and specifically stated that stated in paragraph 4 of the affidavit as under, and endorsement kept issued on 37/2018. Thereby, the order for lancing has been complied. The said affidavit is placed on record. In the above, you will pass the following order. The contempt proceedings shall be dropped. However, needless to observe, it is always open for the complainant to challenge the endorsement dated 37/32/2018, if so desires in accordance with law. Yes, Sanjan Kumar. That's all. What is the order? I have one subscription, Words Ashwati instead of Manjushri, cast title. Now who has complied? Yes, read.
The circumstances respondent are directed to conduct
Who is the competent authority? Tahsildar. All right. This is 2014. Ah. ಯಾವಾಗ done what date? ಅದು ಕ್ಲವರ್ ಆಗಿ ಹಾಕಿದ್ರಿ ಅಪ್ಡೇಟ್. Ah, 2014 ಆರ್ಡರ್ 9 months. ನೀವು ಮಾಡೋದು ಅಂತ ಯಾವಾಗ? How many years, sir? All right. After how many days? This is 9/9. Why 9 months? 24/7/2014, 9 months. April 2015. We have done on or before 24/4/2015, and we have done only on 10/2/2022. After how many years? 15, 8 years. More than 8 years. 8 years, almost 8 years. 8 ವರ್ಷ. And the learner will pass also not here. Where is the Tahsildar? Will impose cost. 8 years delay, 8 lakhs. More ಏನಾಗಿದೆ sir? They don't bother the court orders. And ಅಪ್ಪಿಬಿಟ್ಟು ಬಾರಿ ಕ್ಲವರ್ ಆಗಿ ಹಾಕಿದ್ದೀವಿ. ಕಂಪ್ಲೈಡ್ ಅಂತ ಯಾವತ್ತೂ ಏನೂ ಇಲ್ಲ. 2014 you have complied only 22. And the order for single judge are reach penalty, no appeal. Then will impose 1 lakh cost on this madam. Pramod L. Patil. And contempt petition filed in 2018. After 2 years, now 4 years from the date of contempt. 4 years from the date of contempt. Public justice. Will impose 4 ಲಕ್ಷ ಇದ್ಮೇಲೆ ಟೆಸ್ಟ್ ಮಾಡಿ ನೋಡೋಣ. ಏನ್ ಸರ್ ಇವಾಗೇನು ಭಯ ಭಕ್ತಿ ಇಲ್ಲ ಯಾರು ಮಾತು ಸರ್. Government has the government to commissioner. Government will have the deputy minister of all the Tahsildars who are there from 24 July to 14 today. Suppose not that can be doing portfolio. Yes, sir. We'll ask the deputy commissioner to collect the cost from the Tahsildars who are present, who are working from 2014 till today. And the present Tahsildar let him pay cost. And deputy commissioner will collect and will pay, remain to him. Will impose heavy cost, sir. Bunny. $29,400. All right. We'll ask the deputy commissioner. This who passed this order? 10/2/22 to file pass by whom? What to do? As a deputy commissioner, to pay the cost, collecting all the Tahsildars from their personal pockets for violating the quota. It is yet another case where the authorities showing the disrespect to the court orders passed in the 2014. Stop. The present contempt petition filed by a senior citizen aged about 69 years to take action against the accused under the provisions of section 11 Contempt Court Act for willful disobedience of the order dated 24/7/2014 made in WP 9606/2014, wherein the learned single judge directed the respondents or the competent authority to conduct survey, Cody, and Durust work in respect of In respect of land bearing survey 123 for P A I-P4 of Wade Samudra village, Kasba Hubli, Pandapura Taluk, Mandya district. In accounts with law within a period of 9 months from the date of the receipt certified copy of the order. First up, since the accused persons have not complied, the order passed by the learned single judge, thereby the accused was forced to file, the complaint was forced to file the present contempt petition on 24/9/2018 to implement the order passed by learned single judge. First up, on 26/9/2022, the Tahsildar Srimati Nayana Pandapura, Mandya Taluk filed the affidavit at para 4, 5 and 6, stated as under. Next para. The order passed by learned single judge as long back as on 24th July 2014, directing the respondents, the competent authority, the Tahsildar, to conduct PODI, a survey PODI Durast work in respect of survey number 123/PAI-P4 of Wade village, Wade Samudra village, Kasba Hubli, Pandapur Taluk, Mandya district, within 9 months from the date of certified copy of the order. The complainant has sent certified copy of the order along with representation on 23/9/2014. First up, first up, 9 months. The Tahsildar ought to have passed June 24th June 2015. First up, the same was another report 25/6 June 2015. The same was not done. Thereby, the complaint was forced to file contempt on 24/9/2018. First up, even after filing the contempt, more than 4 years, they have not complied. First up, by careful perusal of the affidavit filed by the present Tahsildar who took charge on 29/4/2022, clearly depicts that the PODI, the sketch prepared as per the chart 2 on 10/2/2022 and the entries were made on 9/9/2022 and MR on 9/9/2022 after lapse of more than 8 years from the date of the original order. First up, ಯಾರು 7 ಮುಟೇಶ್ ಆದ ದಿನಾಂಕ 7/9/2022 ಇದೆ. 7/9/2022 after lapse of more than 8 years and 4 years from the date of contempt petition filed. First up, this clearly indicates the authorities and the state government has no respect for the court order. First up, though on the basis of the order of this court, the state government issued circular on 31/2022, directing all the authorities to comply the orders within the time and any persons who violate the order, he has to face the problem. He has to face the music. The circular dated 31/1/2022 by the state government containing 12 directions, which reads as under. Unfortunately, the authorities, though the state government issued circular on paper, the authorities, namely the Tahsildar, are not implementing the circular, nor the court order. Stop. Though the order passed by the third single judge in the year 2014, we are 2022, more than 8 years. The authorities never acted to comply the order. Thereby, they have shown deliberate, willful disobedience, deliberate negligence on the order passed this court. To stop, it is well settled that the authorities acting under the state government, namely the Tahsildar, who are acting as a revenue authority under the Province of Land Revenue Act, are under a constitutional duty coupled with power. First of every public servant is a trust of the society, and in all facets of public administration, every public servant has to exhibit honesty, integrity, sincerity, and faithfulness in implementation of political, social, economic, and constitutional policies to integrate the nation, to achieve excellence and efficiency in the public administration. A public servant entrusted with the duty and power to implement constitutional policy under Article 14, 21, and 300A, under all interrelated directive principles of state policy under the Constitution, should exhibit transparency in implementation and accountable for due effectuation of constitutional goals. First up, unfortunately, though circular issued by state government and repeated orders passed by this court, repeatedly violating the authorities under the state government, the state government has not taken any action such action against incorrigible officers who have not implemented the orders within the time, including the circular. First up, in the present case, the order passed by a single judge, now holding office of the highest court on the land as Supreme Court judge. Unfortunately, the order is not yet complied. It was passed on 24/7/2014. Even after contempt petition filed on 24/9/2018, alleging the contempt, the government or its officers never bothered the contempt proceedings. Thereby, even after delay of 4 years, not complied. At last, on 10/2/2022, by threat of contempt, the order is now complied. Thereby, the court has become an executing, contempt court become an executing court. Thereby, the officers showing not only deliberate violation, willful deliberate violation, and dereliction of duty. To stop, it is high time for the state government to take initiative to implement their own circular dated 31/1/2022 against the erring officers and ensure the majesty of the order passed in this court should be complied, should be followed. Otherwise, there is no clarity. Otherwise, people will lose the confidence That's it. Ready. In the judicial system, full stop. The like any other organ of the state, judiciary is also man by human beings. Hyphen. But the function of judiciary is distinctly different from the other organs of state. Hyphen. In the sense its function is divine. Today, judiciary is the repository of public faith. It is the trust of the people. It is the last hope of the people. After every knock, all the doors fail, people approach the judiciary as a last resort. It is the only temple worshipped by the every citizen of this nation, regardless religion, caste, sex, or place of birth. Full stop. Because of the attitude of the officers, especially the tahsildars, working under the state, the people will lose the confidence in judicial temper. That should not happen. If it happens, the people will lose the faith on judiciary. Because of the deliberate act on the part of the authorities and non-implementation of the circulars by the state government from time to time, the state government and its authorities not implementing the constitutional policy under Article 14, 21 and 300 Constitution of India and all interrelated directive principles of state policy under the Constitution. The aware officer should exhibit his honesty. If integrity, honesty, sincerity not shown, it is the high time for the state government to raise an occasion and remove such officers from the employment of the state. Otherwise, there will no end for this type of litigation. Unfortunately, even after lapse of 75 years independence, the people are not getting justice before the courts because of the deliberate attitude and act of the officers, now unnecessary courts are being blamed by the general public. We should be stopped at this stage. Otherwise, the very system will be shaken. First up, in the present case, after 8 years of the order on 24/7/2014, after I complied within 9 months, that is on or before 25th June 2015, not complied. Thereby, they oppose the tahsildars who are occupying the post of tahsildar at Pandapur Taluk, Mandya district from 24/7/2014 till 10/2/2022 acted deliberately, willfully disobeying the order. When the contempt proceedings initiated, when this court contemplating to insert stringent action against the accused persons, then now they complied on 10/2/2022. Thereby, all the tahsildars who are holding the office of the tahsildar, Pandapur Taluk, from 24/7/2014 till 10/2/2022 are liable to pay the cost. And the deputy commissioner shall collect, deputy commissioner Mandya district shall collect the cost from all the tahsildars proportionately from their pocket and not from the government, and ensure the cost recovered should be entered in the service records. Then only we can implement the orders within the time. Full stop. We don't know. How many officers from 2014 till today? 3 ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು? 4-5 ಜನ.
2 years, 4 months delay by
Thereby, we are considering opinion in the interest of justice to the senior citizen who approached this court from 2014 till today. She has not got relief, and ultimately, by weapon of contempt, now they complied only on 10/2/2022. Thereby, the contempt petition, the accused persons are liable to pay cost quantified as officer concerned, the Tahsildars from 24/7/2014 till 10/2/2022 are liable to pay cost 2 lakhs. Are liable to pay cost of 3 lakhs payable by the Tahsildars to the complainant. First up, the 3 lakhs, the Deputy Commissioner is directed, Deputy Commander directed to recover 3 lakhs proportionately from all the Tahsildars who are holding the office of Tahsildar, Pandavpur Taluk, Mandya district, from 24/7/2014 till 10/2/2022, and ensure the payment of the cost within 1 month from the date of the receipt copy of this order, failing which the Deputy Commissioner Mandya, who is also party to the contempt proceeding, shall be present before this court. Why action should not be taken against him for not implementing the order directing pay the cost. First up, in the above, we pass the following order. Contempt proceedings are hereby dropped, subject to payment of cost for deliberate delaying the proceedings and not obeying the order more than 8 years from the date of the order, receipt of the order, and 4 years from the date of the filing contempt. About 3 sum of rupees 3 lakhs from the Tahsildar, all the Tahsildars concerned from 24/7/2014 till 10/2/2022, and the Deputy Commissioner shall ensure the collect the fine and pay to the complainant within a period of 4 weeks, and the fine collected shall be included in the service record of all the Tahsildar concerned. Accordingly, contempt disposal. All right, cost 5 lakhs. No, sir. 5 lakhs. You are ನಾಚಿಕೆ ಆಗ್ಬೇಕು ನಿಮ್ ಜನ್ಮಕ್ಕೆ. 8 ವರ್ಷ ಆಗಿದ್ದ ಯಾವ ಮನ್ಸು ಬರ್ತೀರಿ? She is a senior citizen, what job for life? 70 years, she is begging for justice, and you people never raise the occasion. Yes. ನಿಮ್ಗೆ ಹೆಂಗ್ ಮನ್ಸು ಬರ್ತೀರಿ? Mr. Government Advocate, you are not representing these officers only alone. You are representing 7 crores Karnatakas. You should have such responsibility while discharging your duty. Unfortunate state of affairs. Except suspension of Tahsildar, nothing will happen. After suspension, by revoking, you will promote as Assistant Commissioner. This is state of affairs. Yes. Hariappa. Hari. ಯಾವ್ದಾಗಿದೆ ಇವಾಗ? ಯಾವ್ದಾಗಿದೆ? ಬ್ರಹ್ಮದ ಅಡ್ಜಸ್ಟ್ ತೋರಿಸಿ. ಏನಮ್ಮ ನಾವು ದಿನ ಹೇಳಿ ಸಾಕಾಗ್ಬಿಟ್ಟಿದೆ. ನಾವು ಅವ್ರ ಕಾಸ್ಟ್ ಹಾಕ್ತೀವಿ, ನಿಮ್ ಕಾಸ್ಟ್ ಹಾಕ್ತೀವಿ ಇನ್ಮೇಲೆ. ಫಸ್ಟ್ ಲಿಸ್ಟಲ್ಲಿ ಆರ್ಡರ್ಸ್ ಬರ್ಬೇಕು. ಆರ್ಡರ್ಸ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲ ಫಸ್ಟ್ ಬರ್ಬೇಕು. ಆಮೇಲೆ ಟು ಹೀರ್ ಆನ್ ಐ, ಆಮೇಲೆ ಹೀರ್ ಆನ್ ಕ್ಲೇಮ್ ದಿ ಚಾರ್ಜ್, ಎವಿಡೆನ್ಸ್, ಆಮೇಲೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್. ಇದು ಬಿಟ್ಬಿಟ್ಟು ನಿಮ್ ಇಷ್ಟ ಬಂದ ಮಧ್ಯದಲ್ಲಿ ಇದೇನು ಮಕ್ಕಳಾಟ. 28 ಅಲ್ಲಿ 24, 28 ಮಧ್ಯದಲ್ಲಿ ಆಗ್ತಿದೆ ಎವಿಡೆನ್ಸ್ ಮಾಡಿ ಅಂತ. ನಾವು ಮಧ್ಯದಲ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟಾಪ್ ಮಾಡ್ತೀವಿ. ಯು ಆರ್ ಅಬ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಲೈಕ್ BBMP ಹಂಪ್ಸ್. BBMP ಅವರು ಇದಾಕಲ್ಲ, ಜನ ಸಾಯ್ತಾ ಇದಾರೆ. ಹಾಗೆ ನೀವು ಸ್ಟಾರ್ಟ್ ಮಾಡಿದಿರಿ. You want action against the all contempt proceedings officers? We will pass a detailed order. Madam, please, should be systematic. List be systematic. Lawyers somewhere, you have to wait for evidence. Will come later. ನೀವು ಮಾಡೋ ಕೆಲಸ ತೊಂದರೆ ಆಗುತ್ತೆ, ನಮಗೂ ತೊಂದರೆ ಆಗುತ್ತೆ. Proceedings, orders, compliance office objection first, then orders, then IA, then hearing before charge, then evidence, then arguments. ಆ ತರ ಲಿಸ್ಟ್ ಮಾಡ್ಕೊಡ್ರಿ ಅವ್ರಿಗೆ. ನಾಳೆ ಲಿಸ್ಟ್ ನಾಳೆ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಟೇಕ್ ಆಕ್ಷನ್ ಅಗೇನ್ಸ್ಟ್ ಆಲ್ ದ ಆಫೀಸರ್ಸ್. ನಾವು ಹೇಳ್ತಾ ಇದ್ರೆ ನಿಮ್ಗೇನು ಇದನ್ನ ತಗೊಂಡಿದ್ರ? ಯು ಆರ್ ಆಕ್ಟಿಂಗ್ ಆನ್ ಫಾರ್ ದಿ ತಹಶೀಲ್ದಾರ್ಸ್. ಯು ಆರ್ ಗೆಟಿಂಗ್ ಸೆಂಟ್ರಲ್ ಸ್ಕೇಲ್ ಎವ್ರಿಥಿಂಗ್. ಮೇಡಮ್ ಇಲ್ಲಿ ಕೇಳ್ಕೊಳ್ಳಿ, ಆಮೇಲೆ ಅವತ್ತ ಮಾತಾಡಿ. ನಾವು ನೀವು ಮಾತಾಡಿದ್ರೆ ಇಷ್ಟು ಅಮೌಂಟ್ ಡಿಸ್ರೆಸ್ಪೆಕ್ಟ್ ದಿ ಕೋರ್ಟ್. ನಾಳೆ ಗುರುವಾರ ಲಿಸ್ಟ್ ಸರಿಯಾಗಿ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಐ ವಿಲ್ ಪಾಸ್ ಅ ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್. ವಿ ವಿಲ್ ಪಾಸ್ ಅ ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್. 1 or 2 remove. 285 applies to you also. Not only civil judge, junior division applies to you also. You pass a resolution. On 4 ಜನಕ್ಕೆ ತಾಕ್ಬಿಡ್ತೀವಿ ನಾವು. Government, the office is working. I court. ನಮ್ಮ ಕೋರ್ಟ್ ಲಿಸ್ಟ್ ಪ್ರಾಪರ್ ಆಗಿ ಬಂದಿಲ್ಲ, ಐ ವಿಲ್ ನಾಟ್ ಟಾಲರೇಟ್ ಮೇಡಮ್. ಹೆಣ್ಮಕ್ಳು ಒಂದು ಗೌರವ ಕೊಡ್ತೀವಿ, ಉಳಿಸ್ಕೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ಎಲ್ಲ ಕಿತ್ತು ಬಿಸಾಕದೆ ಆಚೆಗೆ. ಎಸ್ ಸರಿಯಪ್ಪ. ಎಸ್ ಜಾರ್ದನ್. Last time you have said comply. Today you have said calculation will be made. Where is Kiran Kumar? Why you are not paid? 2015, unfortunately, order passed. We will go on imposing 1 lakhs, 1 varsha. At the request of the accused persons, both accused persons served unrepresented. We are inclined to issue non-bail warrant. The government advocates undertake to file power and seeks 2 days time. Call the matter day after tomorrow. Thursday. Next matter same. Mr. Arun will start imposing cost heavily on these people. No, 3 lakhs. 3 lakhs. Data ಎಲ್ಲ ಬರಿ ಹಾಕೋಣ ಸರಿಯಾಗಿ. Yes. ಕೊಡಿ. ಕೊಡು. What is the order, Mr. Vardharaj? Now what you have done? Paid the compensation now. ಏನಪ್ಪಾ? ಏನು? ಹಾ 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 ಅಂದ್ರೆ ನಾವು ಗೌರ್ಮೆಂಟ್ ಬರೋ 2014 ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ವೇಟ್. Read the order. Read order, sir. Page 5, paragraph 5, order. Within 2 months from there on. This is 2014. We are to 2022. 2 months over, long back. Read. We are not going earlier, sir. Needless to mention. Whether you acquired the land or not. Whether you acquired the land or not. We are just asking you answer. If notification means they can't do anything. If once notification issued, they can't do anything. How many years they have avoided? ಅಲ್ಲಿಂದ ಇಲ್ಲಿವರೆಗೂ ಎಷ್ಟು ಲಾಸ್ ಆಗಿದೆ ಅಷ್ಟು ಕೊಡಿ. We are not concerned, sir. You should have challenged that order. Then you should implement within 2 months. ಬೇಡ ಅಪ್ರೂವ್ ಹಾಕಿ ನಿಮ್ ಕಮಿಷನರ್ ನಮ್ಗೆ ಬೇಕಾಗಿಲ್ಲ ಜಮೀನು ಅಂತ, ಜಮೀನ್ ಬೇಕಾಗಿಲ್ಲ ಅಂತ. Mr. Charity, we want to know clarity from you. Being a BDA council, we are not concerned. Supreme Court stayed this order. ನಮ್ಗೆ ಸಂಬಂಧ ಇಲ್ಲ. Whether this order also monitor, we are not concerned, sir. Whether this order is challenged by any other person, to obtain. The Supreme Court granted blanket order. All the orders passed in respect of BDA stayed. That is the order. Kodi. You will obey the court order. Please, Kodi. Don't take the advantage of the some matter pending before Supreme Court. You are misusing Supreme Court now. We don't know, sir. Supreme Court ಯಾವತ್ತು ಆರ್ಡರ್ ಬಂದಿರೋದು? ಯಾವತ್ತು ಆರ್ಡರ್ ಬಂದಿರೋದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್? 21 ನಲ್ಲಿ. It applies to 2014 orders. ನಿಮ್ಮ ಮತ್ತೆ ಮಾತಾಡಕ್ಕೆ ಇಷ್ಟ ಇಲ್ಲ, ಹೇಳಿ ನಿಮ್ ಪಾಯಿಂಟ್ ಹೇಳಿ. We just playing with the court. Either pay the money damages utilized in 2007 or acquire, pay the compensation immediately. Otherwise, we'll see. Yes. Sir, facts we are not concerned. What is the operative portion of the order? If you are not order bad, you should have challenged. You have no business to interpret the order. We are not here to interpret the orders. Only order is paragraph 5. Avodi. He now want to try the interpret the order, launching the wrong order. Then why are reading, sir? Implement the order. What is the order, sir? Vodi. Operative portion. Not considered. Same shall be examined. Same shall be examined. Result considered shall be intimated to petitioner. Not later than 2 months. It's a mandate. Not just consider. You are not done your job. All right, to turn the charge. Let your commissioner come. Yes. This is Matondo, Bengaluru Destroying Authority. You people, what a yentitar gotilla. Yes. Odi. With liberty to the court to pay in future if needs arise. How arises? All right, as per law, now the file. If contempt account to you, contempt is not mentionable. Nin kasta nedappa. You don't want to comply the order. That is your stand. Yananta. What is it? All right. 2014, the learned judge says 2 months. 22, you issue endorsement. Now, munda korteva badkidre. This is the harassment by the BDA. What is the meaning of your endorsement, sir? We are not happy, we'll pay the charge. All right, we'll consider this. You want to get the Nanju Reddy. Achatane. We know, sir, your attitude. BDA attitude, we know. ಯಾರು ಬಂದು ಈ ಕೋರ್ಟಲ್ಲಿ ಏನು ಚೇಂಜ್ ಆಗಲ್ಲ ಅಷ್ಟೇ ತಿಳ್ಕೊಳ್ಳಿ. You are not concerned, sir. You should have challenged the order. ಆಯ್ತು. You claim the charge, Bama. You record your submission. ಕಾಂಪನ್ಯ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ ರೆಕಾರ್ಡ್ ಮಾಡ್ತೀನಿ ಸಬ್ಮಿಷನ್. ಬನ್ನಿ. Just now said in the open court. All right, we'll consider. Mister, we are not concerned. You are interlinking other matters. We are just asking this matter. If Supreme Court says any of the BDA matters, any order passed by the Karnataka Court as a single judge division bench should not be complied with the Kodi, we'll comply that. Don't interlink. Some matter pending before Supreme Court, nothing to do with this matter. ಈ ಸಂಬಂಧಪಟ್ಟಂತ ಕೊಡಿ Supreme Court order. We'll obey. You're just wasting public time, dragging the matter, just using their blood. ನಮಗೆ ಸಂಬಂಧ ಇಲ್ಲ ರೀ. Why should we go by other matters? We are not concerned. We are just asking to implement 2014. ಇದು ಆಗೋದಿಲ್ಲ ಹೇಳಿ, you claim the charge. ಆಮೇಲೆ ನಿಮ್ದೆಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಬಾಮ. You claim the charge. Let your commissioner present before the court. We are not happy with the affidavit. Not necessary, sir. No, sir. Bama. So unfortunately, you just playing with the court. Not only harassing the client, you are harassing the court from 2014 till 2022. And you say, easy again. It happens to charity. Ignore. You are applying a movement for BDA. As a citizen of the state, it happens to you. What you are responsible? What you are responsible, mister? You enjoying the property 2007. See the state of affairs. What type of BDS are you meant for development, destroying the citizens of the state? 2007 in the German ತಗೊಂಡಿದ್ದೀರಾ? ಬಿಟ್ಬಿಡಿ. File a memo. Will not take this land. Let them enjoy. File the affidavit of your commissioner, will not touch their lands. They are happy. ಅದು ಬಿಡಂಗಿಲ್ಲ, ಅವ್ರ ಕಾಂಪನ್ಯ ಕೊಡಂಗಿಲ್ಲ, ನೀವು ಅವ್ರು ಸಾಯ್ಬೇಕು ಜನ ನೇಣಾಕೊಂಡು. What type of BDA? Whether we have said already, BDA, government, corporation, they are litigating. They are not assisting the court, nor assisting the people of the Karnataka. You are just litigating. Their blood, their flesh. Yes, Mr. Vadrajan. ಅವ್ರ ಪೊಸಿಷನ್ ತಗೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು, ತೊಂದರೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರಲ್ಲ, ಇವತ್ತು ಕೊಡಿ, ಅವ್ರು ಏನ್ ಬೇಕಾ ಮಾಡ್ಕೋಬಹುದು ಅಂತ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಕೊಡಿ. ಏನು what happened? Land still existing, some buildings are constructed. ಏನು ಆಯ್ತು ರೀ, ಇವಾಗ ಏನಾಗಿದೆ ಲ್ಯಾಂಡ್? as it is vacant land. You are not doing anything. ಮೊದ್ಲು ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? You produce prior to 2017 ಏನ್ ಅಗ್ರಿಕಲ್ಚರ್ ಮಾಡಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ 2007 ಇಲ್ಲಿವರೆಗೆ ಕಾಂಪನ್ಸೇಷನ್ ಡ್ಯಾಮೇಜಸ್ ಬಾಮ. It is yet under unfortunate case at the dictum of the BDA. The complainant, though got the order in the 2014, he is suffering and is before this court in the present contempt petition. To stop. The present contempt is filed by the complainant to take against the accused under the powers of Section 1112 Contempt Court Act for willful disobedience of the order dated 12/8/2014, made in WP 28/0/13/2014, wherein the learned single judge, while disposing of petition, passed a detailed order as under paragraph 5. To stop. Since the accused has not complied the order within the time, the complaint was supposed to file the present contempt petition at date. Well, what is the date of original date, Mr. 16 January 2019? 2019, and now on 29/11/2022, the Commissioner Bengaluru Development Authority filed the affidavit and stated in paragraph 5, 6, and 7 and 8 as under. By perusal of Annex R1, endorsement dated 23/11/2022, even today, the BDA is not willing to comply the order, but nicely stated that action will be taken in accordance with law if they are liable to pay the compensation to the real owner. First off, we are not happy with the affidavit filed by the BDA in compliance with the order of the next single judge dated 12th August 2014, wherein the learned judge directed the second respondent BDA, the first respondent BDA, shall examine the result of consideration of the representation and shall be intimated petitioner as an express manner, but not later than 2 months thereon. In spite of the order, more than 8 years elapsed, the accused has not raised the occasion to implement the order. Only after contempt filed on 16 January 2019 and after notice issued by this court and after several dates of proceedings in the present contempt petition, now the affidavit filed 29/11/2022. To stop. To any of the above, we have no option except to summon the Commissioner BDA before this court to hear and frame the charge. Call this matter and so on so, to hear and frame the charge. The Commissioner BDA shall be present before this court. Yes, sir. Yes. Now, Nimatta Matadi, why should we use our energy, everything? ನೀವು ಕೇಳಿದ್ದನ್ನು ಹೇಳಿ ಬರ್ಕೊಂತೀವಿ ಮಾಡ್ತೀವಿ ಆಮೇಲೆ ತಗೊಂಡೋಗಿ ನಮಗ್ ಗೊತ್ತಿಲ್ಲ ನಾವೇನು ನಿಮ್ಗೆ ಯಾವ ಆಕ್ಟ್ ಹೇಳೋದಿಲ್ಲ. ಮಿಸ್ಟರ್ ಚಾರಿಟಿ, ವಿ ಆರ್ ನಾಟ್ ಹಿಯರ್ ಟು ಅಡ್ವೈಸ್ ಯು. ನೀವು ಕ್ಲಾರಿಫಿಕೆ ತಗೊಳ್ಳಿ ಹೋಗಿ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಮುಂದೆ. ಗೌರ್ಮೆಂಟ್ you want a clarification of the single judge order before the government. You are not concerned. Yes. Rajpati, you are fighting before the, not only against the clients, against the judges also by the BDA. Your attitude you are using. You have no business to say anything. You are not happy. Challenge. Yes. Ragupati. 8 ವರ್ಷ 9 ವರ್ಷ ಅದು ಯು ಆರ್ ಆಲ್ಸೋ ಕಮ್ ಫ್ರಮ್ ದ ವಿಲೇಜ್ ಅದು ಗೊತ್ತಾಗುತ್ತೆ ನೀವು ಇಲ್ಲೆಲ್ಲ ಹುಟ್ಟಿರ್ತೀರ ಟೌನ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಏನು ಕಷ್ಟ ಗೊತ್ತಿದೆ as a lawyer just ignore appealing for a BDA as a lawyer it happens to your client what is your response to your client ಏನ್ರಿ ಸ್ವಾಮಿ 8 ವರ್ಷ ಆರ್ಡರ್ ಆಗಿದೆ ನಿಮ್ಮ ಆರ್ಡರ್ ಮಕ್ಕಳು ಏನು ತಲೆ ಮೇಲೆ ಹಾಕೊಳ್ಳೋ ಟ್ಯಾಕ್ಸ್ ಉಗಿಯಲ್ವಾ ನಾವು can you respond to your client it happened to you happened the ವರದರಾಜನ್ ಅವ್ರು ಆನ್ಸರ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಕ್ಲೈಂಟ್ಗೆ ಸುಮ್ಮನೆ ನಿಂತ್ಕೊಂಡಿದ್ದಾರೆ yes they are answerable sir ಆರ್ಡರ್ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಕ್ಕೆ ಏನಾಗಬೇಕು ಆರ್ಡರ್ಗಳು ವಾಟ್ ಪಾರ್ ಬೇಕಾಗಿಲ್ಲ ಯು ಶುಡ್ ಹಾವ್ ಚಾಲೆಂಜ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆರ್ಡರ್ ಸರಿ ಇಲ್ಲ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಅಷ್ಟೇ ಎಸ್ ರಘುಪತಿ ಏನಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ 1 week time is granted finally to come to office objections. Come back. ಅಮ್ಮ ಹಶ್ವಾಗ್ತಾ ಇದೆ ತಲೆ ಓಡಲ್ಲ ಮಧ್ಯಾಹ್ನ ಬರ್ತೀನಿ
It all depends.